G'day everyone, and welcome to week 5 of our legal ethics course. Last week we started the process of looking at the rules that bind practitioners during their day-to-day practice of the law. We started out by looking at the fundamental duty of any practitioner, which is their duty to the court. However, provided that duty is being satisfied, the practitioner's second duty, and the duty that we spend most of our days actually executing, is our duty to the client. For the next 5 weeks, we're going to be focused on various aspects of this duty. This week, we look at the solicitor-client relationship. Next week, we look at legal professional privilege. The following week, we look at the concept of a conflict of interest. And then in weeks 8 and 9, we look at the obligations that solicitors have when dealing with their clients' money, with trust money. So let's begin. The first thing to understand is that the relationship between a legal practitioner and their client is essentially a relationship established by and governed under a contract. It's tempting but wrong to see the solicitor-client relationship as being a relationship with some other special sort of character. Fundamentally, there is a contract between the client and the legal practitioner. In general, the way that this contract works is that the client agrees to pay money and the practitioner agrees to provide certain defined legal services. That almost always includes the provision of advice. It may also include the provision of representation, including representation in court. It may include the provision of certain financial services, such as being the stakeholder of monies during a major purchase. It may involve services such as acting as a trustee or the executor of a will. It may involve writing correspondence, or 100 different other things, depending on the precise situation and the precise legal services that are required. In a case called WONG against Kelly, the appellant, Wong, was challenging the authority of the Australian government solicitor to prosecute him for smuggling on behalf of the Comptroller General of Customs. Justice of Appeal Stein very clearly said, "Retainer is a word used to describe a contract between a solicitor and client for the provision of legal services for a fee." So, understanding that we are fundamentally talking about a relationship in contract law suggests to us that in the event of problems arising, the client's remedies are also going to be the sorts of remedies that arise under contract law. So, for instance, if you miss a filing deadline and as a result the client loses the chance to appeal, well, then the Law Society might consider whether you require discipline. But in addition to this, we can almost guarantee that your client will see this as a breach of your contract and they will want damages. Now, this being the case, it becomes crucial for us to understand just how the contract is established. Now it's clear, and again Wong and Kelly is the authority, that a retainer contract can be established simply by the conduct of the parties. These days, it's almost inevitable that the contract will be established in writing. Your firm's insurers will almost certainly demand that a retainer be in writing, and Section 208 of the Legal Profession Act requires that you provide clients with a range of information about costs and how costs will be calculated. Those retainer documents, crucially, will also set out the precise scope of what the law firm has been asked to do. For instance, let's say you have a client who's involved in a contract dispute. They contact your firm and they ask for written advice about the meaning of one term in the contract. If that's all you've been asked to do, well, that's all you've been asked to do. You haven't been asked, for instance, to advise the client about their overall prospects. You haven't been asked to advise them about other aspects of the contract. You haven't been asked to act in any sort of a representative capacity, for example, by contacting the other side. So if you spend time and effort doing any of those things, you can't bill for it. It's stuff outside the scope of your retainer. So getting the retainer right, getting the contract right, and ensuring that both sides agree that it properly reflects what the client wants done and what the firm wants to do, well, that's crucial. The contract between solicitor and client does, however, have some unusual aspects. First, quite obviously, the contract is subject to the surrounding framework of rules. So, for instance, you can't make a contract with your client under which your client agrees that you can just ignore the solicitor's conduct rules. That should make sense because, as we learned last week, your duty to the court comes first. Second, the relationship of solicitor and client automatically creates what are called fiduciary duties. I'm going to presume that most of you have already done equity, and so you probably don't need a revision session on fiduciary duties. However, for those of you who may not have done equity yet, a fiduciary duty exists in a situation where one person, the fiduciary, agrees to take on special responsibilities to put the welfare of another person, the principal, ahead of themselves. There are many types of fiduciary, but some categories, like solicitor-client, are automatic. Once someone is your client, then within the terms of the retainer, you must scrupulously place their interests first. Finally, the court will construe the contract between solicitor and client contra proferentum against the interests of the solicitor. So if there's any doubt, the client gets the benefit of that doubt. This is not the case for extremely sophisticated clients, but for our purposes, you can assume that a retainer contract will be construed contra proferentum. I'm sure by now you can see how important it is to get that retainer right. But it doesn't stop there. You see, it's not at all unusual for retainers to evolve. Remember the example I gave a few moments ago where someone comes in and they ask you to give them analysis and advice about a particular contract clause? Well, let's say you did that, and the client was so happy with the job that they asked you to start drafting more documents, say the statement of claim. At this point, if you did the work, you would be going beyond your retainer. Not cool. So it makes sense that at this point the retainer needs to be updated. Sometimes this happens half a dozen times as a matter evolves, but it's necessary so that the client has the security of knowing precisely what work you're doing for them, at what estimated cost, and you have the security of knowing that you're only doing work that the client has agreed to for a cost that they've agreed to pay. Now, there are some retainers that are a bit unusual. For instance, there are retainers where the lawyer agrees to act without fee. We call this pro bono work. Your insurer will almost certainly require a client agreement, even for a pro bono case. In that case, it's not strictly a contract because the other party is not paying any consideration. Don't be fooled by that. Your obligations to a pro bono client are every bit as important as your obligation to a paying client. In other circumstances, the client may be someone different to the person paying the bills. So, for instance, you might have a client who's receiving legal aid funding, or they might have had their claim subrogated or taken over by their insurer. It's crucial that you should always be very clear about who the client is and who is authorised to give you instructions on the client's behalf. If you take instructions from the wrong person and your client suffers a disadvantage, then you'll need your own insurer on speed dial because you will have breached that contract or you'll be liable for negligence. Now, retainers can end in a number of ways. Ideally, of course, the retainer ends when the practitioner completes the scope of works and the client pays their bill. However, it may also end in other ways, and most client agreements contain provisions to allow this. For instance, the client may decide that they no longer want to be represented by your firm. Sometimes this happens because they're unhappy with the work. Sometimes it happens because you're giving them good advice, but it's not the advice they want to hear. And sometimes it happens because they're running out of money. Could be anything. In these circumstances, though, the solicitors retain what is known as a lien over the client's documents. In other words, even though many of the documents on the client's file are the property of the client, the solicitor is entitled to hold them and not return them to the client or send them to the client's new solicitors until the client settles their bill. Finally, the firm itself can end the retainer. This sometimes happens if the client has ceased to provide instructions, so they've just disappeared. Sometimes it happens if the client stops paying their bill. At first, you're just down tools, but eventually you're going to end the retainer altogether. Finally, this sometimes happens where there's a breakdown in the relationship between solicitor and client. For instance, the client might be demanding that you do unethical things. They might not be listening to reason. The client might be really critical of one aspect of your work, and they might express this in a way that makes you unwilling to work with them. They might call and abuse you because of how long legal proceedings are taking. Usually it makes good business sense to just calm the client down and help them to see that you're doing your best on their behalf. However, sometimes the situation will be beyond repair and the retainer must be terminated. So that's a general outline of the main dimensions of the solicitor-client relationship. In the next video, we'll get a little bit more specific, focusing on the duty to provide your client with your best advice.